Dozens of students demonstrated outside the Supreme Court as inside the justices questioned attorneys in what legal experts call the biggest student speech case that's been argued in 2 decades. The court's decision coming from this case could affect freedom of speech rights for every single school child in public schools across America.
January of 2002 was a big day in the history of Juneau, in that it was the first time not only in Juneau's history but in Alaska's history that the Olympic torch run was going to come through town. It was the run up to the Salt Lake City Olympics, and it was a very, very big civic event and popular event in town. It was also an interesting event in the sense that there's only one way in and out of Juneau. You can get there by boat, you can get there by plane, but then when you get to the city, there's only one road going into Juneau, and that's on Glacier Avenue. Glacier Avenue runs from the airport to downtown Juneau, and that was the route that the torch was going to take. Well, that morning it was snowing, it was cold, and there was a huge turnout. The school district in Juneau had excused almost all the kids from elementary school up through high school to line the pathway of the torch run. And as the torch runners came down Glacier Avenue, surrounded by camera cars and Pepsi bottling companies handing out Pepsis and throwing Frisbees, a kid named Joe Frederick and 13 of his friends held up a 14-foot banner right across the street from Juneau-Douglas High School that said "Bong Hits for Jesus." They did this just as the runner with the torch and the camera cars came by. Standing across the street was the principal of Juneau-Douglas High School, Deborah Morse, and when she saw this banner go up, she immediately crossed the road with an assistant principal and a custodian and told the kids to take the banner down. 13 of them immediately dropped the banner and ran off. Joe Frederick, who was the instigator of this affair, stood there and argued with Principal Morse about his First Amendment rights, saying he was across the street, he was on a public sidewalk, he had the right to hold the banner up and wasn't going to take it down. So the principal gathered up the banner with the help of the two colleagues, ordered Joe to meet her in the office, and the whole controversy essentially develops from there. What happens is really a matter of debate. It's a subject of serious disagreement. At one point, this is sort of a sidebar, but it fits in with the timeline, all right? An early chapter in my book I called Rashomon in Juneau, and I call it Rashomon referring to Akira Kurosawa's famous movie in the late 50s, which is the story about a samurai who is killed in a bamboo glade, but then there are 5 different versions of the story. You never know exactly what happened. It's presented from different points of view and different perspectives of individuals. Well, that's exactly what happened in the principal's office. So it's very difficult for me to tell you definitively what happened in the principal's office. From Joe's point of view, he was interrogating Principal Morse about why she was intruding upon his First Amendment rights. He was quoting Thomas Jefferson. He was making the case that he and his friends had this right to hold up the banner during the torch run. Principal Morse, seeing Joe Frederick through the lenses of sort of a difficult troublemaker in high school, at Juneau-Douglas High School, started going to what's called a grid. Now, a grid matches student behaviors with student penalties, and she ended up suspending Joe for 30 days, and as he continued to argue with her, Morse said he actually went around the desk and looked over her shoulder at the computer that she was working on. She felt intimidated. She had left her door open so her administrative staff could watch because she didn't trust Joe. She ratcheted up the penalty, and she also added a criminal trespass order, which literally banned Joe from campus for the duration of his suspension. So Joe, in his inimitable fashion, a couple of days after this encounter in the principal's office, by the way, going back to after Principal Morse imposed the penalties, she asked Joe to leave the building, and he refused to, so she and Vice Principal Staley had to literally walk Joe out of the building to begin his suspension. A couple of days later, Joe was in the municipal swimming pool parking lot, which is immediately adjacent to the high school, about maybe 10 feet from the property from which he was banned. Literally in the face of the administrators, Staley, the vice principal, came out and called the police on Joe. I mean, so all of this is by way of indicating to you that there's a very adversarial, very contentious relationship between the principal and Joe Frederick. Juneau is isolated. It's fairly remote. A lot of kids grow up in Juneau and are sort of at loose ends and don't have a lot to do. Joe is sort of one of those kids. He was a little more enterprising and started sponsoring concerts and other sorts of activities. But a lot of kids run into dead ends and brick walls in Juneau, and unfortunately end up doing serious damage to themselves with drugs. At the time we were there, and at the time this whole situation unfolded, there was a serious OxyContin epidemic in Juneau. And so drugs were on the minds of a lot of the residents of Juneau, and this banner could be interpreted as drug speech. Bong Hits was were the first two words. So a lot of the community said, look, we've got an OxyContin epidemic. This kid's holding up a sign that says Bong Hits on national television during an event that we had all invested in a whole lot of energy in and in which we were taking great pride. Deborah Morse did the right thing, and she was a hero for a lot of the members of the city. On the other hand, a lot of people saw Joe as sort of a hero of First Amendment rights, standing his ground for the rights of students to say their speech. And they would say things like, so what does Bong Hits for Jesus mean? Frederick wasn't a whole lot of help here because he insisted it meant nothing, that it was a prank designed to get TV time, right? Their 15 seconds of fame or whatever. So Frederick was deliberately opaque about the meaning of the banner. But a lot of people then just held Joe up as I say, an icon of First Amendment speech. Another part of the story is that Deborah Morse is something of a recluse. I use that word advisedly. She's not really sociable. She spent a lot of time in her office. She didn't walk the halls and press the flesh with the students. She was seen as kind of remote. And the way that played out is that here's Deborah Morse, sort of antisocial, not having any sense of humor, not seeing the kind of irony in the prank. She should have just let it go. Joe appealed his suspension and criminal trespass order, first of all, to the superintendent of schools, and the superintendent upheld the penalties. Then he appealed to the entire school board, and the school board unanimously upheld the penalties. Third stop was the U.S. District Court for the District of Alaska, and Joe sued, saying that Principal Morse had violated his First Amendment rights, and he also asked for damages, monetary damages, for the injury inflicted on him by the principal. John Sedgwick was the judge who heard the case, and he basically sided with the principal on all the counts. He said that the principal had the authority to tell Joe to take the banner down. He did not uphold the suit for damages, and he did it in what's called a summary judgment, which is also part of another problematical part of the story, because if we're looking at a story that is dividing not only Frederick and Morse, but divided Juneau, choosing up sides as to which side was the one they believed or agreed with. Judge Sedgwick did not help the situation by granting summary judgment because he never heard a trial on the facts. He simply agreed with the principal that as a matter of law, she had the authority to tell Joe Frederick to take the banner down. Next stop was the Ninth Circuit Court of Appeals. And typically courts of appeals hear cases in the first instance with a panel of 3 judges. They don't hear them as an entire court. That's called en banc, E-N-B-A-C. So 3 judges of the Ninth Circuit Court of Appeals overturned Judge Sedgwick's summary judgment, sided with Joe Frederick, saying that he did have a First Amendment right to uphold the banner, and then it went up to the Supreme Court, and that's how we ended up with Morse v. Frederick. Morse v. Frederick is such an important case is because the last student rights case was heard in the 80s, and so it was like a 20-year hiatus between the last case involving student speech rights and school authority. The landmark case comes out of the Vietnam War. It's called Tinker versus Des Moines. It involves some kids who wore black armbands to school in Des Moines public schools, protesting the war in Vietnam and mourning the assassination of John Kennedy. School district told them to take the armbands off or they'd be suspended. Long story short, they didn't take them off. They were suspended. It went all the way to the Supreme Court, and by a vote of 7-2, the court famously held that students do not shed their constitutional rights at the schoolhouse gate. All right? So that was sort of the baseline. However, as I say in the book, the Tinker decision is tentative in that it was not a broad-brushed, unequivocal endorsement of student rights, because what the court said is although students do not shed their constitutional rights at the schoolhouse gate, they have to exercise those rights in a way that does not cause a disruption or violate the rights of other students. Every Supreme Court decision has all these ambiguities in it, right? They're not black and white. There's several shades of gray and ambiguity. So Tinker stood for student rights, but stood for student rights exercised in non-disruptive ways. Well, then along come a whole series of other cases. I won't necessarily go into it, but to answer your question, by the time Morse versus Frederick got to the court, it was very clear that in this balancing between students' rights and school authorities, the balance had tipped in the direction of school authorities being able to maintain discipline, pursue the educational mission of the school, and essentially, as we were talking earlier, student rights were put in the context of the school that had other responsibilities and other obligations, and so in the trade-off, oftentimes student rights took a second place to school authorities and school responsibility. When Joe sued the school district, the ACLU joined in the litigation, and they hired one of their advising attorneys named Doug Mertz, who's a very well-respected attorney in Juneau, to represent Joe. Doug Mertz represented Joe at the district court level and all the way up to the Supreme Court. Mertz is a member of the Supreme Court bar and actually argued Joe's case before the Supreme Court. The school district originally hired a guy named David Crosby to be Deborah Morse's attorney, but when it was clear that they had lost at the Ninth Circuit Court of Appeals and the stakes were getting really high, they went out and tried to find a high-powered attorney, and they found one in Kenneth Starr, the Lewinsky prosecuting attorney, right? The Whitewater prosecuting attorney. So Ken Starr was up against Doug Mertz before the Supreme Court. Ken Starr is a former Solicitor General of the United States. He had hired John Roberts, the current Supreme Court Justice, not only once but twice. So it was, in a way, it was sort of like David versus Goliath before the Supreme Court. And the way the court saw it, by a vote of 5-4, was that Bong Hits for Jesus could reasonably be interpreted as drug speech, and as drug speech, the principal, Deborah Morse, had the responsibility to make sure that it was taken down because it was disruptive. Back to Tinker, right? Students have rights, but those rights have to be executed or exercised in a way that doesn't disrupt other students' education or the educational mission. The court basically qualified Tinker and said that there's now a drug speech exception. If speech can be reasonably interpreted by the relevant administrator, then it's not protected speech and it can be prescribed. The court said this was an extended assembly, Tiffany. What they meant by that was, despite the fact that school was technically out, the students had been dismissed, they were still on school property and off school property, that the event itself was a school-sponsored event which extended the authority of the principal and others to the event and across the street on a public sidewalk. So they saw it essentially as a school-sponsored event along with which went the authority of the principal to determine whether this was disruptive speech or not. Deborah Morse, she was feeling snake bit. Now that's not my word, that's David Crosby's description of his client. And what he meant by that is that after all was said and done, she somehow wishes that she'd never even gotten involved in this, because people would come up to her in the grocery store, for instance, and read her the Riot Act, or friends she thought were friends would suddenly drop out of her life, and she was getting a lot of criticism in the press, and she found herself very, very much unhappy and regretting her whole role in the whole situation. I mean, you think about being sued for damages. The school district has an insurance company. If she had lost and there were damages assessed, She would have been indemnified by the insurance company, but there would have been a judgment against her. Now, judgments against you, legal judgments against you, echo out. It affects your credit rating, it affects your ability to get a mortgage, a whole lot of consequences. Plus, it's a huge stigma. And I think in a word, that's exactly how she felt, was stigmatized by the whole affair. She thought she'd done the right thing by going across the street and interrupting this disruptive event. But a lot of people didn't see it that way. She thought that Joe was essentially, in a way, what's the word I want? Intimidating is not exactly the right word, but was essentially had a vendetta against her. Both sides took this very personally, and she saw Joe as essentially carrying out this vendetta against her, and she never really understood why he just didn't let the matter drop. Joe, unlike Deborah Morse, is not introverted nor shy. He's a very articulate kid. He sees himself as like on this moral crusade to defend the rights of students to exercise their First Amendment rights. He, on the other hand, saw Deborah Morse and Dale Staley, the vice principal, and others in the administration at the high school carrying out a vendetta against him, that they just didn't like him because he was an outsider, he was outspoken, he was articulate, and they were essentially out to get Joe Frederick. So it was like this clash. That's why I titled one of the first chapters in the book Rashomon. It's like everybody had their version of the story, which became capital T truth, and they became sort of a crusade. So Joe saw Deborah Morse as out to get him. Deborah Morse saw Joe as out to make her life difficult, and we were off to the races. What it says is the same thing that a lot of other student rights cases say, and that is that student rights are qualified and dependent upon the educational context within which they take place. And necessarily then, student rights are limited. They are not the same as adult First Amendment rights, which is sort of a difficult pill for a lot of people to swallow because the language of the First Amendment is so absolutist, Tiffany, right? Congress, I call it 10 little words. Congress shall make no law abridging the freedom of speech. Well, what part of no law don't you understand? Some people. Well, the court understands that no law must be interpreted contextually. So it differs from context to context. And in the educational context, student rights are dependent upon those rights being exercised in ways that don't disrupt the educational mission. That means drug speech in Joe Frederick's case. That means lewd and obscene speech in Matt Frazier's case. That means that if school newspapers are publishing controversial articles, they can be censored by the teacher and the principal. That means that if a kid goes out for sports, they can be subjected to random, non-suspicion drug tests. All of those cases, which figure in Joe and Frederick, Morse versus Frederick, all those cases add up to the principle that in the context of a school environment, students' First Amendment and Fourth Amendment rights occupy a lower level or second tier.